It's one of my favorite kabukas. Greetings, greetings. I had some interesting conversations today with some of my brothers and my sisters as we dealt with legal terminology. And as we were talking about, we're dealing with our building of a nation. And in the process, in our nation, we seek to, I guess you could say, codify our laws within our divine principles and having a divine understanding of the development of that foundation. And when we were building, it brought me to a realization that our community lacks an understanding of certain elements, and it's left them vulnerable to the system. And when we say vulnerable to the system, I have brothers and sisters call me every day. I still do legal work. Like I still do paralegal. I'm still what you would call almost like a jailhouse attorney still. Brothers I did time with, I'm still writing the motions for certain ones of them and their families and their friends. And it brings me to a realization that we need an education process in our community. Now, I know a lot of brothers and sisters have been coming into the knowledge of UCC, and they have been building with a lot of the Moors. And so I know a lot of brothers want to walk in standing on their nationality and so forth. But I would say that a lot of times we still have to give the basic education so that brothers can and sisters can survive the system. Number one, you get locked up. What is one of the first things that you want to do? You got a pending case before you. Judge denies you of a bond. You're sitting inside. You're trying to figure this out. Let's say for one, you have a constitutional claim, whatever the police did, they did something wrong. So you know that you got a constitutional claim, you know you're right. And you know you're right. I got these constitutional claims, I know I'm right. The police did me wrong, they did me like this. How do you proceed? All right. A lot of brothers, they try to proceed in ways that is not cohesive in what they call procedures. And I say this because I want to explain this to brothers, is that the first maneuver that is done against you in the legal system is to procedurally bar you. And when I'm saying procedurally bar you, you have to understand this is chess, not checkers. So procedurally barring you is not just at when a judge or when a judge says you've been procedurally barred on a motion. Procedurally barred is a technique that begins at the beginning of the game. The minute, well, then I want to say game, that begins at the beginning of the trial, begins at the beginning of your case, the beginning of that fight of your life. At the first stage, they're going to render you nothing. And that means the first stage, you have the right to an indictment, you have all of the information of your case. So first things is, get the information of your case. Do not be foolish. Do not be foolish. Do not be foolish. If you're in the federal system, you file a Jinx Act, you file a discovery package in your state systems, and you file for your discovery first stage. First stage. Get your discovery package. Get your indictment. Get all of the legal papers that are directed with your information on it. Now, once you have these, you're able to study from a constitutional point. Now, I say this because this is the beginning of you litigating your case and understanding where they made mistakes at. Now, most brothers and sisters, they cry they want an attorney. Oh, I got to get it. Yeah, you get an attorney. But you need to know these things, because a lot of you will hire an attorney, and the attorney will sit there and let months go by and never file for a discovery package, because you don't know that you have to really push them, because we already know they're not working with you. They're not for you. They're there for the people who run the system, because that's where they're going to get 45% of their income is from case cases that are given to them by the state or by either federal systems or whatever. So this is why most attorneys in them don't fight as hard as you think they would. They're not going to do it. They're not going to risk almost 50% of their income coming from state cases and federal cases being appointed to them. If they're a real hard head and act real nonchalant all the time towards the system gives them less cases, they make less money. It's just this, it's the system. Who's the boss. So you got to understand, it's chess, not checkers. So from that component and understanding that, what you have to do, you have to be an antagonist with your attorney. You can't be afraid to be an antagonist with your attorney. What most of you will find out later on, if you are like this, in the end, your attorney will respect you. Some of you may say, oh, my attorney. Yeah, they're going to get upset because they're going to be afraid. And the number one reason that most attorneys have said they're afraid is because they be like, most of the time when they step out there and start taking steps that you may be requesting them to take to challenge the system, most people back up before they go too far. And then the attorney has put their self out there for the person. That's how most attorneys feel. Now, a lot of them are just sellouts and they're working for the system, but a lot of them that are good attorneys, they want to see you say or push them before they go hard, because they want to know most people are going to complete the process. So let's say, what's the first process? You want your discovery package. If you got a cousin or a family member that's went to jail, went in there sitting there with a pending case, and they calling you and they talking about money, ask them, have you got your discovery package? Have you told your attorney to put in a motion for your discovery? Boom, stage one. Now you get all of the paperwork. Now you want to see if everything's been done right. Was the warrant signed right? What was the probable cause determination? Is there paperwork that was signed like an affidavit by an officer that would testify to a magistrate or to a court to get a warrant for your arrest? What did this officer say? Can there be something contested in it? Can you find that there is a perjury in the statement of the officer? These are the things you want to look for. That's the first little stages. Because as I said, all of these things you want to bring up at the beginning. Why? Because it's chess, not checkers. Remember what I said, the first stage in the battle is they want to procedurally bar you. So the first thing is, if you miss any argument or miss any component that is good for your case, and you fail to raise it at the appropriate time, it becomes procedurally barred for you to raise it later on. Now, if it's a clear-cut error where the court has violated your constitutional rights, you can appeal it on that actual innocence. You've got things in the Supreme Court cases that allow your case to be open. But if they can rule that what you're arguing is harmless error and it wouldn't have changed the mind of a jury, or it wouldn't have changed your sentence or so forth, this is what they look for. They look for language to liquidate the process that they've done on you. And so it starts in the very beginning, that if you are not on top of every stage of the argument, even if you want to say you're sovereign, even if you want to say you're sovereign and you're this and that, you can say that at the beginning. But at the same time, in the interest of necessity, you need to defend your case. A lot of brothers in them are going there. Yeah, they're gonna send you to the mental clinic if you say you're sovereign, and they're gonna make you sit for a little while. And after you get your evaluation, then you come back and you start off. Remember, and this especially with federal cases, when they send you off for mental evaluation, you just got to stand strong on whatever you're saying. If you say you're sovereign or however you're standing for it. Once you go through it, they're going to send you back. But remember, none of that time counted. See, that's how they try to psychologically trick you. Right before they send you off, they let you know, as long as you're going through this evaluation, none of this time counts. And until the evaluation people say that you are mentally fit to do your time, then none of that time will count. So they try to scare you that you're going to get a mental evaluation that's going to just, they're not going to do it. That's part of it. If you standing on what you standing on, you're going to have to take all the hits with it. Now, getting back to the procedures. Now, when we're talking about at the beginning telling your attorney that you need a discovery package, you don't just tell your attorney. You write a letter, you put it together. You can head it like a motion. And the one key thing, it doesn't matter how you write it. If you write it out, you can write on there basic. You don't have to know legal knowledge. You can write exactly what you want, and then you write on there, I want the court to consider this as a motion, and I have served this to all the required parties. And then you write the address of the prosecutor on there. You write the address of your attorney. So the courts will receive, and they'll say, well, you got an attorney, you don't need to file a motion. But now it's put on record that you are requesting this attorney to file for a discovery package, to file for your indictment, to file for these paperworks that you need for all of the evidence involving your case. Now, once you do that, see, now the attorney has to do it, because he knows if he doesn't, you're setting him up. See, it's chess, not checkers. You're setting the attorney up for ineffective assistance of counsel. See, now this is a trendy this is this is a long process. Yeah, you might be sitting in the county, but you got to know these basic things. Now, what are other techniques? Now, I'm going to keep going with the courts, but I want you to understand other first techniques. Because if you feel like you're locked up and you're wrongly locked up and it's some illegal, unconstitutional things you're going through, there are other things that you can do. All right. Let's say the sheriff, whoever the sheriff is in your county who's holding you, wherever you're being held in a jail, that's the first person you go to. You first give them notification that you have been brought into their custody illegally or you're being held unconstitutionally. You give them notification. Why? Because they're the holder of you at that time. So once you start the service process, you want to always, because in every jail they got these request forms, and that means it's going to be documented and registered, and it's just like certified mail and stuff. This is how they're supposed to process request forms inside of a county jail. But you always would want to ask for a copy. They're supposed to give you receipts if you do one in the county jails or in the prisons. They're supposed to give it to you. So the first thing, and this could be for a warden, if you're in a state, whatever, the people who hold you in custody, you exhaust your remedies to them. So this is the same in prison. It would be the same in the county jail. So if you were in the county jail, the person who holds you in custody, you start exhausting your remedies. You get the request form and informing them that you're being held illegally. Why? Because everybody that touched you or held you illegally, you're going after them. Same way they go after you. See, it's got to be a double-edged sword. You're fighting your case, but you got to always go at your attacker. The hands that reach out to grab you, that's the vulnerability. Whoever the hands are holding you, remember when you reach out, you have no strength out here. So the hands that's holding you, that's the vulnerability. That's what you attack. So in that process and understanding that strategy in law, you start serving them because they're violating your constitutional rights. They're holding you illegally. An officer did an illegal search and seizure on you, and then when you told them that they were doing something, they just pushed forth and locked you up because they were mad about something that you were saying to them. So guess what? That county jail sheriff that's holding you, you put all of that on paper and you inform them of that. And you start the process and you let them know based on the Uniform Commercial Codes, this is a notice. And then every time you're exhausting your remedies. Why would you exhaust your remedies? Because under the Patriot Act, the only way you can file a lien or you can make a lawsuit against it, I'm just saying liens because a lot of brothers understand the powers in the liens. The only way you can do this is if you have served a party 3 times. That's what avoids you from getting a domestic terrorism process for using the lien process. That's what they did to scare people. So if you understand the processing of the paperwork, then you would always be all right. So if you're in the county and they just brought you in there and you know it's illegally, you start going after the sheriff. Now, what's another process that you can do? The inspector general. Always remember all states, the prison systems, everybody, they have an inspector general. You look it up wherever you're at, the inspector general's office, and you make a complaint about anything unconstitutional. You're putting it all on record. Remember, if you are in the sovereign's process or whatever you're doing in any other process, you're exhausting your remedies in all the capacities that there is. That's what you do. And that means you're putting pressure from all points. An inspector general gets to investigate anybody that's dealing with certain governmental funds, the federal funds. If you say that they're using governmental funds to violate constitutional rights, an inspector general has to investigate it. So we have to learn these measures in our so-called system to use to exhaust at certain levels. Why would we be doing this? It's setting up. Remember, this is chess, not checkers. So now let's say you're proceeding. You're trying to get your lawyer to do this, get your lawyer to do that, and the lawyer is not doing what you need the lawyer to do. This is what happens with a lot of the young brothers in the system. They're not really. Listen, the first thing you should do is start going to the law library. You should tell your cousins, your brothers, your sisters, whoever, if they're locked up and they're calling you, you ask them that one question first. And this is how you see if their mind is correcting and they're thinking about their time for real. You say, have you been to the law library? Have you put in a request to go to the law library? How many times have you been to the law library this week to research your own case? This is the things that, like we say, our brothers and sisters, they go in there now, they still trying to prove they're a thug, but I do this, oh, I don't think nothing about it. Then when they get up the road, they crying. But what done happen is when they get up the road, 2 years done gone by, so now they don't have no right to appeal because they didn't exhaust certain remedies at the beginning. They didn't file certain things at the beginning. So now when they get finally up the road, sat a year in the county, went through transits and went through this, and now it's been almost 2 years, and they get to the prisons where they're supposed to sit at, and now they're trying to do their appeal, and they find out they might have 1 month to put their appeal in. They might be about to run out of time to put their appeal in, and they don't have the paperwork to file an appeal because they never filed their discovery. So now they trying to get their paperwork so that they could get somebody to help them file an appeal, and then guess what happens? They don't get it in time, and they're procedurally barred. And now they have to find a way to get back in court. Once you get in that position, it's harder than ever to raise anything constitutional. You could be right. You could have all of the constitutional arguments to show that this case is bulljive. But once you get procedurally barred, now you got to fight that to get in the court. And I've been in the prison system with brothers, and I've been helping brothers, and I've seen brothers come and say, man, this system, man, they doing us all kind of way, man. Everything I file, man, I'm showing them, man, constitutionally this and this and this, man, and this and this, and the judge just ignoring it. And I don't know what I'm gonna do, man. And I said, well, let me see the paperwork. What's going on? I look at the paperwork. I said, bro, it's not, the judge is they haven't even got to your constitutional claim. What do you mean, man? I'm telling them constitutionally this and that, and it was an illegal search and this and that. I said, man, they ain't even get to know. They ain't talking about no Fourth Amendment or nothing here. What they're telling you is that procedurally, these claims are barred because you failed to raise them in a timely manner. And now you're trying to raise them at this level. What do you mean? Well, this is where it comes in at. After sentencing, see, this is why I say at the beginning, you got to put all your stuff in place. You got to get your discovery. Everything that you want done, you want to do letters or you want to do motions, and you sending it to your attorney, but you also sending it to the court, and you also sending a copy to the prosecutor. So then that means everything's documented. So now if your lawyer fails to do something or doesn't do what you need him to do or doesn't raise it how you want him to raise it or doesn't say this, if you told the lawyer to say this on the record or say that and they don't do it, and you can show that this failure, this attorney to do this was a failure to protect the constitutional right, then when you go to what's called direct appeal, see, right after sentencing, you have a direct appeal. All right. After your direct appeal, if you don't win your direct appeal, you got another appeal. You understand? So that second appeal is like your last hope in a certain sense. But your direct appeal, they say this is where you want to win at. You want to get it in at. Because this goes straight to the appeals court. And after that, you got to appeal back to the court that sentenced you. You got to appeal back to the court you went to trial. But on your direct appeal, you appeal to a higher court. So at that stage, that's where all of your moves prior have to be put in. They have to be put in. You want them to come in into this direct appeal. Some attorneys will say, well, I don't want to raise this and I don't want the court to say this is frivolous and that. Sometimes you got to tell your attorney, man, I don't care what the court say, put it all in. Because the same way a prosecutor will give you 35 charges and know only 2 of them is real, and they just stack up charges so to make you fight so many charges, it's the same way you have to do back with them. You have to come from all of the constitutional points and errors that you can find, and you make a prosecutor spread their argument to try to fight it. You don't want them to be able to key in on your strongest point just in a direct appeal to try to attack it. So you spread it out, you build it up, but you keep your strongest point solidified. And that's strategy. See, you got to think law strategy. And a lot of times our young men, yeah, y'all out here in these streets and y'all talking bully and y'all talking gangster, but you don't have no sense to be thinking about how you have to face your enemy. You know, so this is what the stages is. So now you do your direct appeal. You put in all of this stuff. You're trying to put in all this stuff. Let's say your direct appeal doesn't go through. Now, in your direct appeal, most of the time, the attorney you went to trial with is who will be raising your direct appeal. Okay? Most of the time, the attorney you went to sentencing with will be doing your first direct appeal. Now, anything that attorney made a mistake on, didn't raise, didn't argue, in the next appeal, you file an ineffective assistance of counsel, and you're going to use that to push the case back into court. Because if not, you're gonna be in some procedurally barred elements. So this is why we have to start educating our brothers and sisters about how this system really works and in understanding this. I always tell brothers and sisters, listen, every month there is called a Federal Register that is put out by the federal system. It's called a Federal Register. And they list all of these different things that are being implemented into federal policy. And then they put these phone numbers and these emails and these things that you can go on and you can object as a citizen if you want this to be policy or not. But most of our people don't know this. Now I'm going to show you how powerful this was. That it was the first time I ever seen where citizens were up on this. Because now and this is still with procedurally barred. Now, because the citizens were up on to the Federal Register, what the government had did, the Drug Enforcement Agency, they had slipped the herbal element kratom, Kratom. Kratom is a good natural herb pain pill. What happened is in China, they used to use it to help them get off of the opioid. But the British came back and they made the kratom illegal because they didn't want the Chinese to get off of the opium. This is how they were beating them, by putting them on drugs. That's crazy that the British abandoned something, a herb, to keep the people on drugs. That's what they did. And so the kratom has been illegal even in America for, not in America, but in colonies and stuff for a long time. But the kratom started coming back into movement because we have an opioid epidemic here in America. We have a heroin, we had a fentanyl epidemic here in America. So what's been happening is Europeans, mostly Europeans and mostly a lot of the Asians and so forth, they know that the kratom is a healing plant and it's better to use for pain than the opioids, and it helps the body wield itself off of the opioids because it helps it go through the fight of withdrawal symptoms. So this kratom was put on a DEA list. to be put on the drug characterization. And what they had to do before they did that, they had to put it in the Federal Register what they wanted to do. Do you understand that? So that means all of the drugs and everything that you had, see, supposedly they ran it through a federal process and the people were supposed to vote and say that they agreed to that. And that's the procedure. So what happened with the Creighton is they put it in the Federal Register, and Europeans, because they're fighting a higher number of opioid cases, they were keenly on to the fact that this was in the Federal Register, and they were all filing and voting and writing and sending in the phone calls to buck that the DEA make this a drug and make it unsellable to the people. And they stopped the process. Now, if they had not got on top of that in a fast pace, if they had not did that and nobody had filed and nobody had knew it got put in the Federal Register, then later on we would have seen the people say Creighton is illegal and it's going to have to be removed from stores. And so people who were fighting opioid would now have to try to illegally find Creighton. And they would have been running and scrambling and trying to figure, oh, I got to buy as much Creighton before they take it off all of the shelves and all of this stuff like that. And then they would have been coming around trying to see if you had Creighton and it was illegal and so forth like that. And then if you tried to fight it later on, it would have been procedurally barred because they had already ran it through the Federal Register and gave you an opportunity to object. See, so our community has to understand this process of procedures is what defeats us. They encode it. The encodements. That's why the law is encoded. So what? It seems in our psyche like it makes it difficult for us. Then they write it in this they write most of the laws of America in old English type of old Bible English type of language. And so automatically on our people's psyche, it makes them start saying, oh, I can't understand this shit. But they have to just take their time and just say, hold up, man, hold up. We taught these people encodements, laws, and how to do all of this. So why am I acting like this is above me? It's not. To simply stop and breathe. Because I remember when I was going through the same stages as most brothers, I was arguing. I was like, man, the judge blocking my case. He wouldn't let my shit in and da-da-da-da. And I stopped. One day, took myself out of emotions and put myself in my intellect. And I stopped reading from emotions. And I read and I seen that the judge and them were strictly stating that there were procedures. And because I didn't understand these procedures, it were certain steps that I missed. And so I didn't know how to process my case. And most of our brothers and sisters that go into the system, this is what they fall into. And there's lawyers that'll sit back and take that state money and just watch them. And if they don't know what to push these lawyers to do and how to make sure this lawyer doesn't procedurally nullify all of their arguments by not raising them, then that's what's going to happen to them. They're going to get exploited by the system. So we have to properly educate, not just in uniform UCC uniform commercial codes, but in understanding the system that has enslaved us in so many forms. We have to understand how to maneuver through this operation. We just can't just have brothers being resistant to it and saying it doesn't apply to them, and then they still don't know how to maneuver legally in operation with it. Why? Because you have to exhaust your domestic remedies. And that's on every level, meaning before you can go to the federal, you got to exhaust your remedies for state issues and to the state. Then you can go to a federal court. Before you can leave federal court, where would I go after federal court? You go to the Supreme Court. But let's say you do state and you do federal. You've exhausted your domestic remedies. Now you can go to other courts outside of America, UN courts and so forth. But you have to understand the procedures. Or if you went to go to an international court to make claims about racial profiling and so forth, but you haven't strategically process this through our domestic system, when you get to the international courts, they're going to tell you they can't hear your claim because it was not domestically processed. So learning this is not just to America's court system or anything. It's learning how the world operates in a procedural manner. And we must learn this, or we will be illiterate to how we're being defeated. Right now, what is about to happen? You hear them saying the World Health Organization is setting up a pandemic operation for all of the world, and they will be able to implement it in all of the different jurisdictions. Well, before something could be implemented at that magnitude, what are the procedures in your state and in your federal system that they have to do so that they could do it, that you don't really are aware of, that has to be processed through you, but they will process it, and if you don't take part in it, that's your fault. Do you know what they are? How do you do it? Because, I mean, most of you have seen where people have brought up cases and fought cases that had nothing to do with them. But it did have something to do with them. So even when you think that's like the case that everyone's talking about now. The case went to Supreme Court. Most of us had no idea about it, right? The case goes to the Supreme Court. It's about, this battery going low. The case is going to Supreme Court, and they put the case out, and it gave the Border Patrol 100-mile jurisdiction from the border on out. And that meant it took, and they removed the Fourth Amendment right, because the Border Patrol would be able to annul Fourth Amendment. But none of us knew this case was going to the Supreme Court. But it was put in the news, it was registered, and it was put in there. But did we know that it was going to take away our Fourth Amendment right? No. If we did, we could have filed a curiam with the court case to the Supreme Court. We could have filed the motion to that and put our own argument to protect the Fourth Amendment right of the people. But because we didn't, it's chess, not checkers. They were maneuvering for a position that we didn't even see in their system. Now, the importance of this is like this. I want you to understand this. Now, this Fourth Amendment infringement been ruled on by the Supreme Court. We've heard the people say that this has happened, but we don't know the case name. I haven't heard nobody say the case name. First, we're not educated on it. And now, we've allowed it to get to a level where we procedurally are barred from making an argument against it. And that means our Fourth Amendment rights have been waived, and we ain't even got no argument. We can't even argue against it. Are they appealing this case? Should we be putting together our own crew for all of these black communities that will be brought into the dimensions of this case because Fourth Amendment rights are gone? So shouldn't we have a team of black attorneys going around educating black communities so that they can put a collective argument together against the Supreme Court that this infringes on all of us? But this is a process they've been taking part. They've been setting in place. Now, makes this so deep is, now, all of us are tied together and everything means something. Now, there may be a street dude who had a Fourth Amendment case. Ain't nobody thought about it. He didn't stand up on his rights, so it kind of processed. But his case might have key points that would be grounds to overturn this ruling. But because this street dude didn't take his case serious and nobody don't know it and nobody didn't keep up with it, we don't know that there's language in it to contest some of the language that the Supreme Court did to give an appeal component. So these things become very important on us as a community and our community organizations and groups to make legal watch teams to be onto this and to be in the community, because every young man's case, every young sister's case in your community means something to how your rights are protected. It's not just them going to jail. It's not just them that lost the appeal. It's not just them that's getting messed up. No, these are strategical moves against your community's rights and how to attack you and invade and infringe on your human rights. You have to understand this and know this, so everyone counts. You thought that was just a loser in your hood? No, that person is important to the protection of your hood. So we have to protect every one of us, and we have to be up on what's going on, because the language is in this. Like in Georgia, their case where they went all the way in, and the Georgia Supreme Court ruled that a company could fire you because you had natural hair. How could they let this get all the way to the Georgia Supreme Court, a case that was talking about black people's natural original state being unacceptable? But then they quote equality. How could the court be ruling and dealing with a case on the natural state of black people's hair, and then at the same time say they're ruling on equality? And they ruled that this kinky hair, could be a reason for an employee to fire you. But EOA, you got equal opportunity. What are these people talking about? But because of certain things that have took place before and how they processed these policies, and they processes this language, they have procedurally put it in place, and we have waived our rights to objections to it, and it becomes the way they maneuver. They have other things in law that are called customs, meaning that certain things can be a custom and become a standing in law because it is customary. So these things we have to learn to challenge too. So we got brothers and sisters. You getting. Well, that's Instagram going down. We got brothers and sisters. You getting Board of Education jobs. You're getting this and that. You have to be able to then go into these companies and jobs and look at their policies and look how they have maneuvered and set strategical positions in the language of their policies and stuff that are undermining our liberation, undermining our true liberation for redefining ourselves in a free capacity. No, we haven't been able to define ourselves totally in a free capacity. Yeah, we've been able to define ourselves as athletes and actors to assimilate within their system. But as we talk about defining ourselves in a free capacity, then we're talking about a total another aspect, meaning defining our history, defining our story, defining our destiny as a people, and the oneness of our people and the protection of our heritage. We have not been allowed that. And we're coming to that stage. But yet at the same time, as I said, Georgia Supreme Court in the 2000, when that was 2020, Georgia Supreme Court rules that how are we going backwards unless there's been procedures that we've overlooked that allowed them to feel comfortable with these things? Or people who are of our color, of our melanated nature, going in office with these people and making them feel comfortable with language that is a chess process to delineate us away from rights and take us away from our strategical positions to protect our heritage, our culture, and our identity, and to protect us from social engineering that engineers us to poverty and destruction. So even in our politicians' capacities of wanting to be politically correct, some of them are so politically correct, they are political allies to our destruction. And we have to understand this and then know how to procedurally process them for taking part in that. And we have to know how to read into the laws. Like a lot of people miss that. A lot of brothers and sisters with Stacey Abrams. No, brother, hold up. They put Stacey Abrams in with an agenda, and they gave her an agenda. She didn't just come in now. What was her agenda? What did she say was her running agenda? And then you define it based on your community and your community needs and what your community has stood on and what has balanced your community and what is taking care of your community. See, because now the agenda that they come in under is totally opposite from this reality of your community, then it's not your community's agenda. So when Stacey Abrams came in, she came in with a law agenda, with a legal agenda. Do you understand? With the law agenda, with the legal agenda. And if she does this law agenda and gets our people through with this law agenda and they become complacent with understanding it means and they let her push it, then all of a sudden they find out that they have waived their right to object to this law agenda. And then this law agenda is a procedure that's going to hurt them in the end. But now, because they followed her, they've waived the right to stop it. See, these are the things we have to understand with political agendas and political politicians. Because a lot of them are not as intelligent as you may think, and some of them are intelligent, but they're allowed to be wavered into an agenda that they know they're doing for a political party and not for the people that put them in power. Oh, that's a big difference. So Stacey Abrams came in with the legal agenda of, she brought this case, and it was the case where a gay couple went to a restaurant or so forth, and they were denied service. And the restaurant denied them service on Religious Freedom Restoration Act. That based on their restaurant was based on their religion. I believe it was a coach. I don't want to say what it was because I'm not fully remembering, but whatever it was, is that based on their religion, they had the right to protect the integrity of their spiritual beliefs and say that they don't want to seem like they're worshiping or idolizing something that they're not supposed to. So they rejected the gay couple. And so they so-called tried to take this and make this an LGBT reality. But that's not. That's not an LGBT fight, because LGBT, listen, has to understand and look at what certain things are. So they said, well, under LGBT, we're going to fight to remove the Religious Freedom Restoration Act and remove religious exemption. Now you have to understand, that religious exemption doesn't go one way. That religious exemption helps people through a lot of things. Some people wanted natural healing, so they didn't want vaccinational processes. They had the right to natural healing. But if you remove Religious Freedom Restoration Act and you remove certain religious exemptions through that process, now that's a chess move. And then now when other things come back around and people go together in religious exemption and they say, no, based on so-and-so case and based on this policy implemented, you are procedurally waived your right to challenge this. Then we're put in another position. And that's what happens in this legal atmosphere. So when I listen to a lot of people and I hear them and they talk for the politics, they talk for this and talk that, but I think on legal strategical strategies that protect the interests of the people, not on just that basic elementary or voting right kind of concept and politicians put a politician in. No, you got to think a lot deeper in this time, or else you will do just like Martin Luther King said. You will be leading your people into a burning house. So being at that piece, I hope that the bill gave you certain elements, and I hope that it can be used for people to review in a certain essence, to tell their cousins and certain people first stages in their case what to do. Get you a discovery package. Make sure you stay on top of your case. Read everything. File everything. Stay on. Make all of the things to the records. Put them on record early. Try not to let nothing get procedurally barred. That is your first stage of your battle. That is 101 in the beginning. So next time we'll go a little deeper in some other little techniques. Things like how do you file this? How do you do that? How can you do it? What is a nut protunct? How do you use a nut protunct? and so forth. So we'll go a little further in that next time. Peace, one love, Legal Build.